Our final case on the argument calendar this morning is State versus Wardle, case number 20230761. If I could get counsel to state their appearances for the record, please.
Sarah Carlquist on behalf of Mr. Wardle.
Good morning.
Jonathan Bauer on behalf of the state.
Good morning. All right. You two have been here probably more times than I have. So I take it we don't have any questions before we begin.
Two former clerks at this
Exactly.
court, and always a pleasure to have that wonderful occasion.
That fact is not in my memory, but I appreciate that comment, and we're obviously, as always, pleased to have both of you here. So, Ms. Carlquist, we'll turn the time over to you.
May it please the court, Sarah Carlquist on behalf of Mr. Wardle, I would like to reserve 3 minutes. To overcome the privilege that HD had in the medical and mental health records sought below and under the version of Rule 506 in effect at the time, Mr. Wardle had to show 3 things. 1, that HD had a condition. 2, that her condition went to an element of Mr. Wardle's defense. And 3, that the requested records were reasonably certain to contain exculpatory evidence. Because Mr. Wardle made the required showing below, the district court erred when it denied his motion for an in-camera review of the requested records. First, extrinsic evidence in the form of HD's disclosures to police constitute evidence that she has a condition within the meaning of Rule 506.
So apparently the state in that footnote conceded that if this is a repressed memory case, then the condition element is met here.
Correct.
Can you focus on that? Give me your best argument as to why you think this is a repressed memory case.
Yes, the fact is that HD's condition was the fact that this is a repressed and recovered memory case is proven, at least to a reasonable inference, based on the 3 different disclosures that HD made to police. During her first disclosure on April 29th, 2020, that is where she specifically told police that she, quote, blocked this incident out of her mind and recently remembered it after having experienced medical issues. And what we know from our Supreme Court has told us that a reasonable inference, as opposed to speculation, is a reasonable inference is a deduction as to the existence of a fact which human experience tells us can reasonably and logically be drawn from other facts. HD's disclosures are facts, and human experience tells us that when somebody says they blocked an incident from 20 years ago out of their mind and only recently remembered it due to experiencing medical issues, our human experience tells us that that is different than a run-of-the-mill memory problem. But on top of that, we then have her second disclosure, less than 3 months later, where she tells police, you know, I've been remembering more details. I want to tell you what I remembered about this first incident. It's not that she remembered more details. It's that the details and the incident have completely changed. In the first incident, in her first disclosure, she described the first incident as saying she remembered she was wearing a dress. She remembered she was held down with one hand while her underwear were removed with another hand. She remembered being strangled to the point of unconsciousness. Now, 3 weeks later, for whatever reason, this same incident, she is now remembering it as, I was wearing a blue shirt that was tied around the elbow. I had on bell-bottom jeans. Go ahead, Judge Luthy.
It struck me in reading Franklin versus Stevenson that was a civil case, and that in the civil context there would be depositions, and some of this could get fleshed out just in the natural course. There's not that mechanism necessarily in a criminal case, but I'm wondering on this issue of what really is she saying when she says I've just remembered this. If we were to remand for an evidentiary hearing on this limited issue of whether, is she alleging a condition, or what is she really claiming, and would we have authority to do that?
I'm not sure that we would, because I appreciate your point that, part of the reason that we can't, that this is the record that we have, and and that the only thing that we have to deal with are her own words and her own disclosures to police, is because Mr. Wardle was bound over on a paper prelim, and you cannot cross-examine that piece of paper. And we know from Lopez that any attempt to subpoena HD would have been quashed. I don't think there is any chance for Mr. Wardle to flesh this out and figure out what HD means until she takes the stand at trial, which will be too late.
Which is why you asked for in-camera review.
Which is why we asked for in-camera review, and in-camera review, as our Supreme Court in Bell recognized, balances the important privacy interests that people have in their privileged medical records against a criminal defendant's very important federal constitutional rights under the 6th and 14th Amendment to compulsory due process.
So, I mean, I know you may not know exactly how to answer this question, but I'm going to ask it anyway. What is it that one would expect to find? I mean, the therapy records, I guess I get, because that's a little more analogous to the Franklin v. Stevenson case, where you want to, I guess, find out what the methods that the therapist used to maybe elicit these additional memories of the second incident were. But the first incident didn't have anything to do with therapeutic or therapy records. It had to do with medical issues. And so what you're asking for there isn't therapy records, but medical records, right?
That's correct.
So
And-
what are you expecting to find there? I mean, what could be in there that would be useful in terms of how the memory came back?
Yeah, I think that's correct, right? Because our human experience sort of tells us that it's not a regular thing to experience medical issues and then you all of a sudden recover a memory that you apparently blocked out for 20 years. And so our position is that those records are reasonably certain to contain evidence about her condition. It's going to contain evidence about what those medical issues were. Were they mental health? Was it like in Franklin v. Stevenson where the alleged victim in that case started having unexplainable panic attacks that led her to therapy where she then recovered memories? It's going to give us information about what the medical issues are, how those medical issues could have caused somebody to recover memories from apparently 20 years later, and whether, it is reliable or probable that a medical condition could cause somebody to remember something from 20 years ago, and to probe the reliability of, to have an expert say, this medical issue could cause the recovery or couldn't, or calls into question the reliability of the recovered
Let
memory.
me rephrase the question and frame it in terms of the reasonable certainty requirement. I guess it seems likely that you would be, that those records would contain relevant information about how that memory came back. But is that information reasonably certain to be exculpatory, is I guess the issue that is rattling around in my head. Like, we may learn something about how at that medical appointment the memory came back. But what if it's benign? How do we know that that information isn't going to be just a completely benign thing as opposed to something that you could maybe think was exculpatory?
So it would be exculpatory because under Wardle, a condition that goes to an element of his defense is any argument that interjects doubt into the state's obligation to prove every element of the offense beyond a reasonable doubt. And so it could be that it could create a battle of experts, right? Like if a medical professional said, I have never seen this before, I can't explain how this medical issue caused you to remember this event from over 20 years ago, that creates reasonable doubt because it calls into question the reliability of the memory and the process by which it was recovered.
Right, we don't know what these records contain because
That's correct.
nobody's looked at them other than the complainant. But what if the medical professional at issue, and again, I'm talking just about the medical records regarding the first stuff, not the therapy records for the second event. What if that medical professional really had nothing to do with eliciting those memories? It was just something that happened in the course of the medical appointment that triggered those memories to come rushing back, and that particular medical professional isn't going to have anything to say on the subject of how the memory came back? What if it's that?
If it's that, that doesn't, so if it's that, that is determined at the in-camera review stage, right? And the district court could come back and say, you know, just
Well-
because something's reasonably certain doesn't mean that it's absolutely certain.
Well, let me back up. If it's that, do you think that would be exculpatory?
I think that I don't think that we have to show that it's that to overcome the threshold to get to an in-camera review of the records. But I do think that it is something that does interject doubt into the state's obligation to prove this case beyond a reasonable doubt. And it is something that an expert could opine on to explain. You know, it's sort of like the narrative value that the state is often allowed to put on, you know, evidence of other acts for narrative value, so long as it doesn't give rise to a propensity inference kind of thing. It gives rise to a narrative value of like, this is how everything started, and maybe this is what led you to the therapy where you are now recovering more memories.
Well, but it was a medical encounter that apparently prompted the memory.
That's correct.
So I got thinking, what could that be? And I thought, well, maybe it's a gynecological exam. And the doctor says, my goodness, there's some very unusual scarring here. How do you explain that? And she searches her memory. Oh my gosh, as a 10-year-old, I was raped by my uncle. I'd totally forgotten about that. That's got to be the explanation. That seems to me a rather reasonable scenario given the bare bones account that we have here. But I'm hard pressed, as was Judge Harris, I'm hard pressed to see what about that would be exculpatory.
Well, I think that that it could also be something else, right? And that
It could, yeah.
and that we don't.
This struck me as a plausible scenario where this might have come up.
I think that we should be concerned that we don't know exactly what the medical issues are, but we do know that her condition is linked to them, and these are the kinds of questions that the district court can answer upon in-camera review. Because I think that we don't have to absolutely show that it's exculpatory. But, you know, in a hypothetical universe, I think it is just as likely to be the scenario you explained as it is to be the scenario that happened in Franklin v. Stevenson, where the alleged victim started experiencing unexplained panic attacks.
So it seems to me
I think that could count as medical issues. And the fact that we don't know what the medical issues, because they're locked in these records and we had no ability to cross-examine HD and ask her what these medical issues were, that's still enough to get us the in-camera review to determine whether these are in fact exculpatory.
In Worthen, our Supreme Court quoted Blake, another case, but said, we noted that the specific facts required to meet the reasonable certainty test include, but are not limited to, references to records of only certain counseling sessions which are alleged to be relevant, independent allegations made by others than a victim has recanted, or extrinsic evidence of some disorder that might lead to uncertainty regarding a victim's trustworthiness. It seems like those don't require us to point to exculpatory evidence in the way that we can see that certainly there would be exculpatory evidence, but that allows consideration of just really relevant evidence. And if there's relevant evidence, some of it might be exculpatory. Is that really the standard that you're
Well, yeah,
articulating?
I think that's correct. I think it goes just a smidge above relevance to material, and that in the context of this, you know, exculpatory, I think in this context maybe means something a little bit different than what it might mean in Brady. And from Worthen, it's anything that will interject doubt into and the things that you said, Judge Luthi. And I think we'll also acknowledge that just because HD did say she had medical issues, It is possible that when we ask for that subpoena, she tells us she didn't get any treatment for those medical issues and there are no records that exist, but we still need to figure that out. I think we still meet the standard of we've alleged facts based on the totality of her disclosures to police, that her medical issues and any medical records related to those medical issues and her therapy records are reasonably certain to contain exculpatory information to at least get us to that in-camera review.
Okay, thank you, Ms. Carquist. Mr. Bauer?
May it please the court, counsel. Your Honors, the reason that Mr. Wardle got no traction below, and the reason the district court agreed with the victim's advocate, and the reason the district court denied the motion for in-camera review, and the reason this court should affirm are all the same reason. And that reason is a lack of a showing, lack of evidence of a condition relevant to a defense, and most certainly of reasonable certainty. And I think I'd like to start with the reasonable certainty. I think is where Your Honors left off.
Well, if you're going to start there, let me start there too, and have you answer Judge Luthie's question, because it seems to me that the quotation Judge Luthie read from Blake, which was block quoted in Worthen, indicates that the reasonable certainty standard and the whole exculpatory angle on this perhaps ought not be viewed in the same way as it is in Brady. If the Supreme Court indicates that when the request is specific and limited to certain dates and asking for only certain counseling sessions, and there's extrinsic evidence of some disorder that might lead to uncertainty regarding a victim's trustworthiness, that might add up to reasonable certainty of exculpatory evidence. And so I guess I'd like your thoughts on whether the word exculpatory means something different here as it would in another context, given what we're told in Blake.
Specific, like it's in a Brady context.
Yeah.
I
mean, in Brady, my understanding, just to put it on the record, my understanding in Brady is we have to be pretty sure that the evidence is going to help the defendant before the prosecutor's obligated to turn it over, right?
Sure. I'm not familiar with that exact nuance of Worthen and Blake.
Yeah, I'm paraphrasing.
I think what I would say is I would agree it doesn't have to be a showing of a recantation or something of that dramatic nature. But nevertheless, there has to be a showing of something that's going to, even the language that Your Honor just quoted to me about calling into question or what the defendant's arguing. I think what I'd maybe like to do is take us back to the hearing below and to Mr. Wardle's first attorney in the trial court and how they explained why they wanted what they wanted and why they wanted it. And they said what we'd be asking for is for our ability to review those records and to have potential expert review of them to see what inconsistencies or what concerns there are. So he wants the records so he can find out what's in there. That's not a burden of showing that there's something in there that justifies the finding.
It seems fairly probable, if not reasonably certain, that the records would contain some sort of information about how the memory was triggered.
I don't think that's a fair inference from the very limited record that we have at all, Your Honor. And we have really two very different statements, months apart. Hearsay statements. They're not even the words of our victim here. They're the words of a police officer. I don't know if it's contemporaneous or from notes. It wasn't recorded. That's indicated right on the police report. And certainly as to the first.
Would you concede that what's in the reports at least leaves open the possibility that at trial we might find out that she is exactly saying I've had repressed memory?
I don't think the statement completely rules that possibility out, but I do not think it certainly doesn't establish it at this stage. And I think there's reasons to believe that is not the case.
But if you're willing to concede that possibility isn't excluded, then what do you do with the difficulty for the defendant of waiting until trial to find out? And then mid-trial, then one can say, okay, now we need a continuance to to go find out if the therapy was done in a reliable and scientifically reliable way. Is your proposition that we ought to require defendants to wait until trial and then have to fight a motion that, well, you've waited too long, we aren't going to do a continuance mid-trial and all of that?
I mean, that's all speculation, Your Honor, but what I would say is, we have a rule, it's a strict rule, the rule we're under it was in effect for many, many years, many cases from the Supreme Court, from this court, and the standards are what they are, and they're difficult, and everyone understands there's gonna be times when a defendant thinks there was therapy or knows there was therapy and thinks it would be helpful and would really, really like to get, ideally, their counsel and their expert pawing through those records, but if not, at least get it to a district court judge and their staff and possibly an appellate court and these different things. Well, even that first stage of in-camera review that's an invasion of a privacy interest that this alleged victim has when she talked to that therapist. And if there even were medical records during the first incident, which we don't even know that there were medical records. I mean, I think it's so important to look at that, both statements really, but the first statement, and this is just a quote, this is the only record we have. She blocked this incident out of her mind and recently remembered it after having experienced medical issues. We don't know what blocked this incident out of her mind means. We don't know what remembered means in the sense of, is this something that yeah, unfortunately, I remember this, 3-4 times a year because it was awful, and this made me remember it again. We don't know, but for purposes of this, after having experienced medical issues, that could have been self-medicated, that could have been bleeding, cramping. I mean, it could have been at the doctor's office. And again, to Judge Orm's concern, it might not, what triggered the memory could be anything. The nurse might have had the same cologne as Mr. Wardle used to wear, and that triggered.
All right, but
we just don't know.
If there's no medical records on this first issue at all, then what's the harm in sending it back, right? There'd be no loss of privacy interest if the district court on in-camera review, or maybe somebody tells them beforehand there isn't any such records, and then at least we know, right?
Your Honor, with all due respect, what's the harm is an utterly irrelevant question for whether the rule has been met, whether the strict standard has been shown, whether the defendant has met that burden as to the 3 different things defendant has to show to even get to the first stage of in-camera review, much less any sort of.
So is it an element of the test that they have to show that there are medical records?
And I think that's certainly part of what the judge ruled here with the lack of specificity under the Rule 14, sort of a separate issue, but it's also under the reasonable certainty from Blake and Worthen and talking about that's one of the aspects that you have to narrow down.
So what's the harm? You're right. That was the wrong way to phrase that. Let's say that the request, again, I don't have the request in front of me, so I don't know how it was phrased. But if the request is to the extent there are any medical records within 30 days of this date, we want the judge to look at those because we think that has to do with the condition and the element in the reasonable certainty test. And obviously, if there aren't any, then there aren't any. But what's wrong? What would be wrong with a request like that?
I think there was some effort made below, or some we would be talking ultimately about potentially 20 plus years of memory and recollection and possible records over, she may have been in therapy since day one. We just don't know on this very limited record. She'd been to the doctor many times over that 20 years. And I think when the request below limited it essentially to about a 1-year period, I think, so, roughly corresponding with the first statement and roughly corresponding with the last statement about therapy.
Right, but assuming that we get around the overbreadth problem of the request and that they do come up with a request that is appropriately limited to a shorter period of time, and they say, look, we don't know if there are medical records. We think there might be based on what she said, and we would like to look at them to the extent they exist. Can the state defend that by saying, well, you haven't proven that the medical records exist? I guess that's my question. Is that like a element 0 of this 3-part test?
It's the language that was used by the Supreme Court as part of the reasonable certainty test. It's really not, it's my recollection.
Okay.
It really doesn't have to do with the condition. So again, with the reasonable certainty, I think that counsel below engaged with the limited record, I mean, perhaps a little more realistically than counsel on appeal is, in the sense of saying not once, but twice, we don't know what's in there, we want the records so we can have our expert look at this. And that was sort of after it was maybe sussed out that possibly we were kind of talking in the ballpark of repressed and recovered memory rather than simply remembering. And even after that exchange with the, with the district court judge, where defense counsel below, says, well, the concern is that potentially this was a suggestibility or a false memory, and that could be the case. And the judge says, well, how would that be evident from the medical records? And literally the last statement below from Mr. Wardle to the court is, well, that's why we would need our expert to be able to look at that. And then, of course, victim's advocate stands up, points out accurately, in my opinion, that this is a fishing expedition to just try and find something, and has not made these showings. And the first words out of the district court's mouth is, I agree with the victim's advocate. This has not been a showing here, certainly of reasonable certainty. But I'd really like to, get to the lack of a conditional showing as well. Does the court have any other questions on reasonable certainty? Okay. Well, thank you, Your Honors. So as to the condition, I mean, again, we have two different statements separated by months, 10 months. They're really not related to each other at all, except they're all part of the same investigation. And so the first statement, again, to an officer related in his notes, is that she blocked out this incident. Well, okay, we don't know what that means, and I think in the common parlance, when someone says, I blocked out my divorce, I blocked out my parents' death, I blocked out an assault, I blocked out anything, they're not invoking Olson v. Hooley, they're not invoking Franklin, they're not saying, you won't believe this, I'm like one of those McMaster's preschool kids that completely forgot about everything for years, and then it was dragged out of me with, these amazing therapeutic tools that I've never heard of before. That's just not a fair inference from this limited hearsay statement of this young woman. I think go ahead.
If we set aside the notion of repressed memory and just say this is something that she just keeps pushing back and never deals with emotionally. She remembers it occasionally, it comes back to mind over the years, but she never deals with it. The definition in Worthen is a mental or an emotional condition is a state that persists over time and significantly affects a person's perception, behavior, or decision-making in a way that's relevant to the reliability of the person's testimony. It seems to me that if feelings of anger over 6 months, which was the condition in Worthen, qualified as a condition, that a refusal to deal with the experience that happened in over 20 years, never really pulling it out and processing it, whether it's repressed memory or not, that's an emotional or mental state that's persisted over a long time, that's affected a person's behavior, meaning bringing charges or a decision to bring charges in a way that's relevant to the reliability of the person's testimony. And I could certainly picture counsel cross-examining over, well, if it was really that bad, why have you waited 20 years to bring it? How do we not get that it's a condition, even if it isn't repressed memory?
Well, I certainly think Your Honor's right that the appropriate use of these inconsistencies, the appropriate use of these factoids that we're trying to focus on here today, really is cross-examination, closing argument. That's the use of these, and I think the import of these. As to Your Honor's question about whether we even need to get to repressed memory, quickly before it slips my mind, I want to make it absolutely clear. The state is not conceding that repressed memory satisfies Rule 506. That is not what I said in my footnote, and that is certainly, to the extent that it could be interpreted that way, that's not what I'm conceding. I'm saying those facts supported by that record in Olson, in Franklin, there's just a lot more meat on that bone, to use the phrase from in a different context, And if we had that record, then, then we could have that argument. We could have that argument below in the trial court. Victim's advocate could actually engage with that record, and maybe it would even be conceded. I have no idea, but that's the point of saying it could be, because it would be argued on those facts and those additional facts, and that much bigger record of actual experts and actual therapeutic techniques that are of the record in Franklin. Your Honor,
So I've got the one question that's pending, and what you've just said has prompted another. So going back to the question that's pending,
thank you.
could this be a condition? Why couldn't this be a condition, even if it's not repressed memory?
I don't think it's a condition because, as Your Honor is unfortunately aware, we have a number of cases that meet this same basic fact pattern. I mean, they might not have the therapy statement. They might not have the medical issue statement and the block statement. But child sex abuse, delayed child sex abuse prosecutions are unfortunately a fairly regular occurrence in my world as a criminal, appellate practitioner. I'm sure Your Honors have considered these cases before, whether in a Robbins context or an insufficiency context or,
But not a lot of them
Sure.
come up saying, I didn't remember it until now. And I've been getting therapy to help me remember more.
Well, I don't know that, she said she recently remembered it after having experienced medical issues.
And then she
Whether
later says-
something reminded her, every month she's painfully reminded of this, and she finally decides to take steps, whether it's to seek therapy, whether it's to seek justice. I mean, that's, victims behave in different ways because they're all processing what they're processing.
I'm going to follow up quickly on that, and then I'll kick it back to you.
Yeah, 'cause
for
my
your
other one's a
sec.
different-
You have another
different topic.
question, I know you do. It seems like there's two separate claims for records here that are separate in time by about 10 months. One is for the medical records that might exist. As you point out, we don't know that they exist. But the medical records that might exist in and around April of whatever year that was, 2020. And then the other one is for therapy records that apparently do exist. She said she'd been going to therapy around about February of 2021. Do these two requests rise and fall together? Or might we find merit in one and not in the other?
They both fall for lack of a showing. If they made showing against one and not the other, then they would rise or fall separately.
Right, but I'm drawing a distinction because on the second one, with regard to therapy, we do know, or at least we can very reasonably infer that there are records, right? So we're at least
I think that's fair.
we're at least past that hurdle.
Right.
And we know that the statement here, that you're right, it's hearsay, but it's the record we have, that the complainant told the police officer that she had been going to therapy and has remembered more. She links the therapy to the memory in a very direct way. Does that might get us there?
I don't think so without more, Your Honor, because it really doesn't link at that with that degree of specificity. And the burden is not met by showing we could interpret this ambiguous statement. The showing is made by showing, there's some evidence here that the therapy and that condition exists and is relevant. And I want to point out I think one distinction I tried to draw overall between Olson and Franklin, and in this case, to the extent Olson and Franklin are relevant at all here, is this lack of a record, lack of a very well-developed civil record, as Your Honor pointed out.
That's a great segue back to my second question.
Why don't I let you go ahead, and I'll try to remember my other second.
Or why don't I interrupt that before you, I'll wait. Finish your thought.
Okay,
I'm
well,
sorry.
thank you, because I think this is so critical with regards to the therapy records. It is in both Franklin and in Olson, there was no disclosure of the basic fact of abuse. There were no allegations until the therapy created those allegations. Here, by the time she went to therapy, she's already disclosed. She's already disclosed to the officer. She's talked to her aunt about it in the past. That's right in the record.
Different incident though, right?
I'm sorry?
Different incident though, right? Aren't there two counts, and what came out in therapy is what forms the basis for the second count, and what came out in the medical stuff is what forms the basis for the first count? Am I misremembering that?
If you are, I am too.
I think I'm trying to the relevance of the first disclosure is, I think there's a reason to believe if you look at the first disclosure that it might be somewhat of a composite memory of multiple rapes. She remembers being raped, she remembers being strangled, and then as she sorts this out in her head, whether it's in therapy, whether it's with the assistant, or just over time or in her head, and she sorts this out and she realizes, oh no, the reason I remember two different outfits is, because there were 2 different days and it wasn't the first time I was strangled, it was the second time. And that's fertile grounds for cross-examination, fertile grounds for closing argument and factual exploration. But by the time she even before there's any record she went into therapy, she's already made a disclosure. My uncle raped me in my house and at this time frame. I mean, that's a serious allegation. We can all kind of explore later, in trial about, well, gosh, then you kind of remembered more, and isn't that incredible? And do you remember this at all? And I think it's the basic fact she remembered long before there's any evidence of therapy is my uncle raped me. I mean, that predated any therapy. If that was the facts in Olson, she would not have been able to avoid the statute of limitations. If the idea was, well, I remembered more abuse later, but I want to sue this guy for sexual abuse. And I've always remembered prior to therapy that there was this abuse. Well, gosh, that started the clock on that claim, and that was a 12b6 civil case statute of limitations issue.
My second question was this one. Do you agree with Ms. Carlquist that we really don't have a mechanism if we wanted to try to flesh out some of these issues factually before trial? Or could we do an ad hoc 23B kind of remand to say, let's figure out, is this really repressed memory or is this something else?
I'm not aware of any authority that the court had, rule-based authority for the court to do that, and I think I've heard defense counsel suggest that wouldn't be useful. I'm assuming trial preparations will proceed. This is an interlocutory posture. Regardless of what the court rules today, it's going to go back to the trial court, and there could be more discovery, more statements can come up. Whether or not there are formal mechanisms to get particular information, I'm not, as the court's aware, I'm not a trial lawyer. However, I think one other aspect of the record that does exist is that we're looking at these 2 statements that defense counsel pulled out below and has really pulled out on appeal as saying this is what shows the potentially even this Olson repressed memory situation. And if we even look at the record as we have it, we know there's at least 19 pages of police reports. There's 3 of them in the record, and 2 of those cut off in the middle of her statement. Now, I think we can infer that if there was anything else helpful in the rest of those police reports about repressed memory or, Olson v. Hooley stuff, that sort of thing, it would have been in the motion below. The record also
Can we infer
indicates
can we infer the opposite too? That if there were anything damning in there, that the state would have made us aware of that?
No, not at all, because there's no burden at the point of this. This is a 506 motion. It's supported with 3 pages of record, focusing maybe on 2 statements about medical issues and therapy. And I think, as the court can see from the record, that the prosecution allowed the victim's advocate's attorney to speak for the victim on this issue, and between the state prosecutor and the victim's advocate attorney didn't feel the need to bring anything more into the record. I'm not sure how there would be anything more in the record that would. We just don't know that, and that's the problem. But that doesn't get us not knowing, us being curious. That doesn't get the defendant anywhere to meeting the standard, to showing a condition, to showing it's relevant, to showing reasonable certainty. And then one other thing I would point out about the record: the discovery indicates there's two. The way I read the discovery disclosure by the state, I want to say it's record 30, 37, 39, somewhere in there, is there's 2 transcripts, 2 interviews with the victim that were provided to the defendant. And, if those interviews presumably focused on this investigation of this prosecution, if those indicated some therapeutic shenanigans, as in Franklin, these sorts of things that might potentially meet 506, we'd have that laid right out, and it's just not there. So it will go back, one way or the other, this is going back. You know, we'll have a court ruling on one way or the other. It's going back for trial and for further proceedings. And those proceedings could include anything the defendant wants to, you know, try and do as far as discovery or as far as looking at those interviews and renewing their motion. And, you know, maybe the trial court doesn't like that. Why didn't you bring this the first time? Well, I didn't. Here we are, and here it is. But it's not in front of this court. What is in front of this court is 2 sentences out of a 3-page excerpt of the record, hearsay statements, and a trial court's rejection of all 3 of these, the Rule 506 requirements that are the defense burden to show. So I'm out of time. If there's no further questions, I'd ask this court to affirm and remand for further proceedings.
Thank you, Mr. Bauer.
Thank you, Your Honors.
Short person's back here. Sarah Carlquist on behalf of Mr. Wardle. I think it's very concerning that the words that HD disclosed to police were sufficient to charge him with 2 very serious crimes. And on the other side of the spectrum, the same words she said to police that we acknowledge in the totality gives rise to a reasonable inference that she has a recovered and repressed memory, or at the very minimum, as you pointed out, Judge Luthi, a condition that has persisted over time and goes to the very reliability of her testimony. I think it is very problematic that we're only paying attention to the words that were sufficient to charge Mr. Wardle with a very serious crime, and then we can just ignore her other words that are the only words by which Mr. Wardle can mount a full and fair defense. The second thing that I will say is this case is not Bell. Bell was a case that was based on speculation. Our Supreme Court rejected Bell on the basis that his claim for the records was, quote, mere speculation without any factual support. I recognize that the state does not like the factual support we have, but we do have factual support. This case is like Worthen, where there was factual support, and the factual support in Worthen, just to point to some of it, was the alleged victim in that case's own words in the form of her journal entries. And I think that it's really important to note that the AV's journal entries in Worthen didn't say, I have extreme hatred for my parents that has persisted over time and it affects the reliability of my testimony against them, right? I feel like the state is faulting us for dealing with the statements that HD did make. And HD did not have to say this is a recovered memory case. HD said, I blocked this incident out of my mind and only recently remembered it after experiencing medical issues. Apparently, her recall from those medical issues was faulty because 3 weeks later, she describes the exact same incident differently. And then 10 months after her initial disclosure, now that she's been going to therapy, she remembers an entirely new allegation that apparently was not triggered by her initial medical issues, but was triggered as a result of therapy. And that is enough to show that she has a condition, that it is relevant to an element of Mr. Wardle's defense, and that the requested records are reasonably certain to contain exculpatory evidence. And as you pointed out, Judge Harris, like, we are gonna go, if you reverse this court, we still do need to go back and make that particularized showing in a new 14B motion, but it'll be easier for us to get the record,
And
right?
that's hopefully my last lingering question is footnote 6 in the state's brief, where they say, look, the only thing we can do here is affirm on one ground or another, right? The state's position is even if we were to agree with you on the rule issue, on Rule 506, we'd still have to affirm the court's denial here because the court had this other denial reason for denying your request. But that would, on remand, give you an opportunity to cure that with a more narrow request on remand. What's your response to that?
I mean, I think that that's correct, and if I remember the state's brief correctly. I think that they acknowledge that because this is interlocutory appeal and we aren't appealing from a final order, the district court is free to reconsider any order, and that we would be allowed to file, we put a footnote that said we could file a new 14B motion, and that's not an
Yeah.
alternative ground on which we can affirm, because that can be cured below.
Well, I think those are both true statements, right? I think we would have to affirm below because you're not challenging the 14B basis for the dismissal, but the state, your memory is correct, the state does state in that same footnote that the state does not contest that if this court agrees that Wardle has overcome the privilege, he can amend and refile his motion upon remand if he can cure the particularity problems. So I think the state agrees with you that you would be able to at least make a new request on remand, but I still don't think that gets us around the state's point that affirm is going to be the result here one way or the other. It's just if we affirm the state's way, then you're not allowed to go make a new request because the Rule 506 would bar it. But if we affirm your way, you would be able to go make a new request.
Well, and I think that, yes, we could make a new request, but if we go down and make if we go down and make the same request, we still need to correct the error in the second part of the court's order, which is saying that we didn't make the proper showing, because otherwise, we still just have the same evidence that we had to begin with, right? So no matter how perfect our 14B motion is on
No,
remand.
I don't think we're saying anything different. I think we're on the same page
Okay.
there. Like
Okay.
if we went with your way on 506, we would explain that, but I still think the end of result of the opinion would be affirm because you didn't appeal or contest the 14B dismissal, but that result would give you a chance to redo things on remand. But if we went the state's way on 506, we would explain that, and then we would just say affirm, and you wouldn't have the opportunity to go. Does that make sense?
Yes, I think that makes sense, and I also think that if you did go the state's way, it is our position that we could still try again under the amendments to the new rule that are now in effect at the time.
Or you could try again on new evidence or something else, but yeah, right.
Right, but it is our position, consistent with the sort of footnote that the Supreme Court dropped in Chadwick about, we didn't resolve this privilege issue, but the rule has been amended, so parties, court, you should look at the new rule to see how it shakes out in that case. That would be our position, is that, yes, we get to do this over again, regardless of outcome.
Yeah, I'm not sure anybody's asking us to,
No.
Are you asking us to take a position on that? You're
No, I'm not asking you to take a position on the amendments to Rule 506, but I do think that it would be helpful to clarify for the district court that we are allowed to, that we are allowed to relitigate this either based on new evidence or based on the new rule. And in the first instance, we can litigate, it seems that the state is taking a position different than some of the line prosecutors below, that Rule 506 is now in effect and does apply regardless of when the communication happened, but that would be helpful, just so that there's no confusion on remand. We just want everybody to know what can happen on remand.
Okay,
If there are
Thank you,
no
Ms.
further
Carper.
questions, we ask this court to reverse. Thank you.
thank you. Appreciate the arguments made today. Briefing and arguments, excellent as always. We'll take this matter under advisement and issue a decision as soon as we can. Thank you for being here today.